statement of its expert. By a letter of the same day, Myanmar informed the court that it intended to call only one witness and reserved the right to call a different witness if for any reason the former should be unavailable to testify. Myanmar also provided confidential written affidavits for both of these witnesses in the Myanmar language, accompanied by certified translations into English. It further indicated the pseudonyms that should be used for these two witnesses. After ascertaining the views of the parties, the court decided, pursuant to Article 53, Paragraph 2 of its rules, that copies of the pleadings and documents annexed in their redacted versions as appropriate will be made accessible to the public on the opening of annexes that will be kept confidential. In addition, with regard to written pleadings and documents annexed, which contain written statements and accounts given by the witness called by the parties, as well as the redacted version of the affidavit of witnesses and the verbatim record of their testimonies, it was decided that these materials would only be posted on the court website after the end of the oral proceedings. The court also decided to make accessible to the public, on the opening of the oral proceedings, the reports submitted by Myanmar on the measures taken pursuant to subparagraph 4 of the operative clause of the order on provisional measures of the 23rd of January 2020, and the Gambia's comments on them. In this respect, the court notes that our parties were consulted on this matter and did not object to such publication. Further, after consulting the parties and the intervening states, the court decided to make accessible to the public, on the opening of the oral proceeding, on the declarations of intervention pursuant to Article 83, Paragraph 1 of the Rules of Court, the written observations of the states seeking to intervene, and those of the parties on the admissibility of the declaration of intervention in accordance with Article 84, Paragraph 2 of the Rules of Court, as well as the written observations of the intervening states referred to in Article 86, Paragraph 1 of the Rules of Court on the subject matter of their intervention. I note the presence in the court of the agents and counsel of the two parties. In accordance with the arrangement for the organization of the proceedings which have been decided by the court, the hearings will comprise a first and second round of oral argument. The first round will begin today with the oral pleadings of the Gambia and will close on Tuesday, the 20th of January 2026, following Myanmar's first round of pleadings. For the first round, each party will have 6 sessions of 3 hours at its disposal. The second round of oral argument will begin on Monday, the 26th of January, and conclude on Thursday, the 29th of January. Each party will have 3 sessions of 3 hours to present its reply. In addition, the court will hear witnesses and experts between the 2 rounds of oral argument. The witnesses of the Gambia will be heard in 3 closed sessions on the morning and afternoon of Wednesday, the 21st of January, and on the morning of Thursday, the 22nd of January. The expert called by the Gambia will be heard in open session on Thursday, the 22nd of January at 3 p.m. The witness called by Myanmar will be heard in closed session on the morning of Friday, the 23rd of January, 2026. In this first sitting, the Gambia may, if required, avail itself of a short extension of time in view of the time taken up by my introductory words. I now give the floor to the agent of the Gambia, High Excellency Mr. Dawda Jallow. Sir, you have the floor.
Mr. President, esteemed judges, it is an honor to address you today as the agent of the Republic of the Gambia in our dispute with the Republic of the Union of Myanmar. 6 years ago, the Gambia filed its application with this court, seeking to hold Myanmar accountable for its violations of the Genocide Convention. In January 2020, you ordered provisional measures and did so unanimously. We are now finally in the merits hearing, after which the court will decide whether Myanmar is responsible for acts of genocide against the Rohingya group, as alleged by the Gambia. As you will hear over the next 3 weeks, and in particular over the next 4 days, in deciding to bring this case, the Gambia acted on the basis of most careful reflection and assessment of the facts. We did not bring this case lightly. We brought this case after reviewing credible reports of the most brutal and vicious violations imaginable inflicted upon a vulnerable group that had been dehumanized and persecuted for many years. We received and carefully examined the meticulous reports of the United Nations fact-finding mission, dispatched by the UN Human Rights Council. We also examined reports issued by the reputable international human rights organizations, which sounded the alarm on the genocide of the Rohingya unfolding in northern Rakhine State. Those credible reports from diverse and independent sources left no doubt in our minds that Myanmar had to be held accountable for its violations of the Genocide Convention. And so we acted. Genocide Convention is the first multilateral human rights treaty that have been adopted. But its words will be meaningless unless they are acted upon and enforced. It is up to the state parties to the Genocide Convention to invoke affirmatively its provisions in order to truly liberate mankind from the odious scourge that is the crime of genocide. That is why the Gambia invoked Article 9 of the Convention and brought its dispute with Myanmar to this honorable court. The Gambia stands tall in the international community of states and takes pride in promoting and protecting human rights, including international accountability for genocide and other atrocity crimes. We do this out of sense of responsibility, grounded in the history of which we too suffered under a military junta. Over 2 decades of brutal dictatorship have taught us that we must use our moral voice in condemnation of oppression, of crimes against individuals and of groups, wherever and whenever they occur. It is also taught to us that accountability is imperative. Otherwise, impunity will ensure that such crimes are repeated over and over. In present times, these issues are more important than ever. And the court's role is more important than ever as a bastion for the rule of law. Sadly, Myanmar appears to be trapped in a cycle of atrocities and impunities. Nobody has been held responsible for the crimes against the Rohingya. Indeed, the military that perpetrated the genocide actually felt emboldened to overthrow the civilian authorities again. Myanmar's original agent in this case, the former state councillor, Madam Ansu Kyi, has been imprisoned by the military junta, deprived of her liberty since she was swept from power by the same generals who continue to rule the country. And Senior General Min Aung, who commanded the military during the genocide, now rules over Myanmar as the leader of the junta. Predictably, violence and atrocities have spread throughout the country, affecting Myanmar nationals of all ethnic groups. Mr. President, while Gambia is the only applicant state, we are not alone in this cause for justice and accountability. Indeed, as the General Assembly stated in 1946, genocide sucks the conscience of mankind and results in great losses to humanity. And this is because humanity, our shared humanity, is made of various groups protected under the Convention. This is why we stand before you with full backing and support of 57-member organization of Islamic cooperation. We also stand in solidarity with 11 intervening states from across the world who have urged the court to interpret the convention in a meaningful way in the manner advanced by the Gambia. We stand too with the support of dozens of international human rights organizations and defenders whose investigations and reports have corroborated the findings of the UN fact-finding mission and its successor, the International Investigative Mechanism for Myanmar. And most importantly, we stand together with and for the Rohingya survivors of Myanmar genocide. This group of appalling persecution and years of dehumanizing propaganda. This culminated in the savage genocidal clearance operations of 2016 and 2017, which were followed by continued genocidal policies meant to erase their existence in Myanmar. We are proud that, once again, Gambia's delegation includes several members of the Rohingya community, including those who have traveled from the refugee camps in Bangladesh to be with us at this hearing. I invite them to stand so their presence may be acknowledged. Thank you. I turn to the case. It is not about esoteric issues of international law. It is about real people, real stories, and real group of human beings, the Rohingya of Myanmar. They have been targeted for destruction. They are farmers, laborers, teachers, mothers, fathers, sons, daughters, grandparents. They are ordinary folk. They have dreams and aspirations like all of us. And first and foremost, it is the most simple dream to be able to live in peace in their homeland under conditions of dignity and security. Myanmar has denied them that dream. In fact, it turned their lives into a nightmare, subjecting them to the most horrific violence and destruction one could imagine. 3 of the Gambia's witnesses who will testify in closed sessions next week have to endure that nightmare personally. They are first-hand eyewitnesses to the clearance operations that took place in 3 of the villages that were focused on by the UN fact-finding mission, namely Minji, also known as Tulatoli, Chutpin, and Muanu, also known as Monapara. All 3 of them lost family members in genocide. For their safety, we will only refer to their initials when we reference their written and oral testimony in these oral proceedings. Mr. President, members of the court, the Gambia has carefully examined jurisprudence and has fit this court's jurisprudence and has fits its case within that legal framework. There were genocide acts and there was genocidal intent. During the clearance operations in 2016 and 2017 and subsequently. This is evident based on particular circumstances in many villages and Myanmar's overall pattern of conduct. The Gambia believes that the evidence that has been submitted to you and which you will hear described this week admits of only one reasonable inference in regards to that pattern of conduct, that Myanmar acted with intention to destroy the Rohingya as a group, or in whole or in part. The Gambia is proud to be represented by a diverse and talented team of international advocates who will present all aspects of the Gambia's case. 5 of them, including 2 Gambian state attorneys from my chambers, will be pleading before this court for the first time. After me, Professor Philip Sands will introduce the legal context for this dispute. He will be followed by Paul Reigler, who will provide an overview of the Gambia's case in the context of the court's previous 2 genocide cases, and that is Bosnia, Serbia, and Croatia, Serbia. Mr. Aslan Suleiman will then provide an overview of the relevant geography, demography, and history of the Rakhine State and discuss why the Rohingya are a protected group under the convention. In the afternoon, Mr. Reigler will return. In the afternoon, Mr. Reigler will return to discuss the quality and reliability of Gambia's evidence in this case. Then Mrs. Tafagwa Pasipanodia will present the history of discriminatory laws and persecution of the Rohingya in Myanmar, which is one of the indicators of Myanmar's genocidal intent. Mr. Suleiman will return to discuss another of such indicators, Myanmar's year-long efforts to disseminate anti-Rohingya hate propaganda. On Tuesday afternoon, Mr. Andrew Lowenstein will provide an overview of Myanmar's anti-Rohingya clearance operations and discuss how their organized nature and execution constitute another indicator of Myanmar's genocidal intent. Our presentations will continue with 4 speakers who will provide detailed presentation on the clearance operations in specific locations. Ms. Pasipanodia will discuss Myanmar's genocidal attack in Minchi or Tulatoli. Ms. Jem Hong Ho will present on Myanmar's genocidal attacks in Chut Pien. Ms. Ms. Maria Mangom will examine Myanmar's genocidal operations in Muangnu or Monu Port Para. And Mr. Charles Kombenjai will describe Myanmar's genocidal attacks in other notable villages. On Wednesday morning, Ms. Ho will discuss how the extreme brutality of Myanmar's clearance operations evidence Myanmar's genocidal intent. Ms. Pasipanodia will then focus on why the pervasive sexual violence during Myanmar's clearance operations indicates its genocidal intent. She will be followed by Mr. Lowenstein, who will demonstrate that Myanmar's targeting of children is also an indicator of its genocidal intent. After that, Ms. Yasmin Alamin will demonstrate that Myanmar's destruction of evidence is also an indicator of its genocidal intent. And Professor Per Dazin will conclude the morning session with a presentation on Myanmar's pervasive impunity and how that also reveals its genocidal intent. On Wednesday afternoon, Mr. Suleiman will show that Myanmar's argument that its clearance operations were ARSA counterterrorism operations is not a defense to genocide because the evidence fully established that the manner in which these operations were organized and executed contradicts every tenet of counterterrorism doctrine, including Myanmar's own. Mr. Lowenstein will then demonstrate how the evidence described by the previous speakers Mr. Lowenstein will then demonstrate how the evidence described by the previous speakers demonstrates Myanmar's commission of the actus reus of genocide under Article 2 of the Convention. He will be followed by Professor Sands, who will highlight proof that Myanmar acted with the requisite mens rea or dolus specialis of genocide, and that its intent to destroy the Rohingya as a group, in whole or in part, is a manifestly reasonable inference to be drawn from that proof. Mr. Reichler will conclude our presentation on Wednesday by showing that genocidal intent is the only reasonable inference that can be drawn from Myanmar's pattern of conduct across the clearance operations, and specifically that the evidence demonstrates that it would be entirely unreasonable to infer that the intent of Myanmar's targeting, mass killing, maiming, raping of many thousands of unarmed and defenseless Rohingya civilians, including pregnant women, children, the elderly, and the infirm, as well as burning of their houses and razing of their villages, was to combat terrorism. On Thursday, in our final session, Ms. Jessica Jones will discuss other breaches of convention for which Myanmar is legally responsible. Mr. Suleiman will examine Myanmar's breaches of the court's provisional measures order of January 2020. Then Professor Dazan will present the remedies requested by the Gambia. And finally, Professor Sands will conclude our opening presentations on Myanmar's commission of genocide, on the witnesses you will hear, and on the significance of this case. The Gambia will present one additional witness, Professor Michael Newton, who will testify in open session next week. Professor Newton is a former military officer who specializes in the laws of war and counterterrorism operations. His testimony will demonstrate that Myanmar's clearance operations cannot be reasonably explained by the intention to counter terrorism. Rather, the only reasonable inference that can be drawn from its conduct is an intention to destroy the Rohingya group as such. Mr. President, honorable judges, these oral hearings come at a time in which the fundamental principles of international law, as enshrined in the UN Charter, are under stress and threat globally. Many have lost faith in the promise of international law. And many are looking at this case to see if the Genocide Convention is more than just words on paper. We are confident that this court, the principal judicial organ of the United Nations, will stand in the breach and uphold the rule of law, which epitomizes our collective conscience. As the guardian of our moral and legal compass under the Genocide Convention, we come to you because this court is the only hope for justice and accountability that the Rohingya and all people of Myanmar so greatly deserve. Mr. President, members of the court, I thank you for your courtesy and for your keen attention to this case and for allowing me to address you. With your permission, I would ask that you call Professor Sands to the stand. Thank you.
I thank His Excellency Mr. Daud Jallow. I now invite Professor Philip Sands to address the court. You have the floor.
Mr. President, members of the court, it is